Call now the case of Interstate Fire and Casualty Company against Tatiana, Abernathy, and others. All right, we'll hear from the petitioner.
May it please the court. My name is Robert Ball. Along with Larry Matthews, we're pleased to represent Interstate Fire and Casualty Company. If I may, I'd like to reserve 4 minutes for rebuttal, please. This is a case that, frankly, with all due respect to the trial court and to opposing counsel, this case has gotten off track. And this is a case where I appreciate the court allowing us to have oral argument on it, because this is a case where we need to get it back on track. This is a covalence case, which is an unusual kind of situation. I think the facts are important here as to the procedural history, how we got here. This case was filed last August. The suit was filed by the plaintiff where they alleged that on April 14, 2007, Dakota Abernathy was injured at the Jellyfish Festival, which was in Fort Walton. A suit was filed against the Touchdown Club, the local Touchdown Club that sponsored the festival. Also against a company called Emerald Coast that operated the ride in question, and also against Fantastic, the manufacturer of this bungee run. Interstate insures Emerald Coast. They provided a defense. There's no issue about coverage there. Under the Emerald Coast policy, it says that if there's a written contract with a third party to name that third party as an additional insured, then there may be coverage. The Touchdown Club asked to be included as an additional insured, or they sought that after the suit was filed, and Interstate said, is there a written contract? And there was no contract. And so because of that...
There was a certificate, right?
Yes, sir. That was issued 4 days after the event. There was no writing, not a single piece of written paper before April 14, 2007. That was written on April 18, 2007 by Emerald Coast's own broker, not Interstate's agent. There's now, that's an issue in dispute in the underlying case. But the point is that on October 13, Barbara Robity for Interstate wrote to the Touchdown Club and said, we're sorry, there's no coverage because there's no contract in place. So that's when things start happening. Within 6 weeks, the plaintiffs entered into a consent judgment for $6.25 million against the Touchdown Club. The Touchdown Club then assigned all their rights over to the plaintiff, and then the complaint was amended to add Interstate. Now again, keep this in mind. You have the 3 tort defendants, the Touchdown Club, Emerald Coast, and Fantastic, and now Interstate is the 4th defendant added into that same case. Interstate was not given notice of that, as is required under the Florida non-joinder statute. The Interstate first learns this...
wasn't given notice by certified mail.
Or any notice. No, sir. They were not notified of the motion to amend the complaint. They were not told that the complaint had been amended until they were served on January 6th of 2010. So the first time Interstate learns of this is January of this year when they have been served. And so that's the situation here. Again, this is a covalence settlement. And so I'm not arguing about the ability to enter into a covalent settlement. But here's the interesting thing. We have looked at every single reported case we can find in Florida on covalent settlements. We cannot find any other case that's procedurally like this one, where you have one plaintiff against the insurance company and also the tort defendants in that same case. All the other cases, you have a third-party complaint or a separate claim against the insurance company, so that the tort case, normally there's only one defendant, or if there's a couple, that case is decided separately, and the insurance case is also decided separately. That's what we don't have here.
Since you're describing the procedural landscape for us, is there also a federal proceeding of some kind?
Yeah, there was, and that case has been dismissed now. There have been a couple of things that I did want to bring to the court's attention that have changed since the filing or since the hearing today. Number one, the federal court declaratory judgment action was filed. It was dismissed without prejudice in favor of the state court proceeding. They said since the state court case had gone forward, the federal court decided to abstain in light of the state court case, but again, without prejudice, depending on what may happen. The other thing that I did want to bring to the court's attention, the trial court, we had told you in our briefs, had granted summary judgment on the reasonableness of the $6.25 million judgment. That's a subject for another day. There was no discovery on that, and so I'm not going to go into that. But the judge also granted a summary judgment on coverage, on the insurance coverage, just on August 26th. So but what I wanted to point out is that the case is not over as to the insurance issues. We're going to be filing a motion to reconsider on the coverage issue. Secondly, just this week, we have received discovery from the plaintiff, and they are now going to be proceeding on a bad faith claim. So here's the current posture of the case. We've got allegations and discovery as to whether or not Barbara Robedy did something in bad faith by denying coverage for the Touchdown Club when there was no written contract, and the certificate, as you mentioned, Your Honor, was not issued until 4 days after the event. That is still going on. We have those insurance coverage issues going on. At the same time, the tort case against Funtastic and Emerald Coast is still going on. Now, currently, the judge has stayed those tort claims and product liability claims, but we don't know if that'll change, and we don't know what's going to happen there. So frankly, it is a mess having all these lawyers.
Almost down to your 4 minutes, but in this, aren't you in a very thin posture here? You're saying we don't want separate trials, we want a severance. What's the difference? The difference
is that the Florida non-joinder statute absolutely gives the trial court no discretion on this issue. The statute says that you cannot join an insurance company in with the underlying case where the insurance company has denied coverage. And as to the Touchdown Club, Interstate has denied coverage. So the non-joinder statute applies for two reasons. Number one, they can't do it this way. Number two, there was no notice given to Interstate, which would have given Interstate an opportunity to object or also to file a separate declaratory judgment action, which would be the normal way this would be handled.
Counsel, I want you to address the jurisdiction of this court. We're proceeding under a petition for writ of certiorari, and I'd like to understand what the injury to your client is at this point, because the purpose of the non-joinder statute is to not allow the evidence of coverage to go before the jury before liability has been determined against the insured. Here, there's no practical difference. The jury in the tort case is not going to hear evidence of the insurance coverage, and the court is separately determining whether coverage exists as between Interstate and Touchdown Club. So what is the injury that we should look at to determine jurisdiction?
Your Honor, you're exactly right that a lot of cases have said that one of the goals of the non-joinder statute was so that the jury would not be told about Interstate. But also, you have to keep in mind, even if the jury would not be told, and again, with the Koblenz setting, it's a little different than the average non-joinder type case. But the point is the non-joinder statute is unequivocal. There is no discretion to allow these two claims to all be brought in the same case. So even whether or not the jury is told about it or not, the plain language of the statute does not allow this.
What is the irreparable harm? Right. What is the irreparable harm to your client in this case that cannot be remedied on appeal?
The harm to us is that we are bogged down in a tort case, in a products case. We have counsel at every hearing. We're going to have depositions. We're going to have things going forward. We don't know how these two cases are going to proceed from this point forward. And so having this all together, it's an increase in time and expense. And what the non-joinder statute requires is that these cases be handled separately. And that's the way it is done in every other case that we've been able to find.
And again, with the procedural posture we're facing, do attorneys' fees and litigation expense constitute a irreparable injury that can't be remedied on appeal?
Yes, ma'am. We would say, and again, it's not just an expense, but it is a time, a scheduling, and an ability to have these cases resolved separately as they should. Now it's
the big damage is you're an insurance company. You're not a manufacturer. You're not provider of the festival, and in violation of state law, according to your argument, you're being involved in a case in which you have nothing to do.
Yes, sir.
You simply want a separate proceeding to determine liability.
Yes, sir, that's exactly right. Thank you.
Down to under 1 minute. We will add 3 minutes to your time for rebuttal, and we're going to give an additional 3 minutes to the other side.
Great, thank you very much.
May it please the court. I heard a lot about the facts here, but I didn't hear, and I've read the first appellate brief by appellates that was dismissed by the court. I read their petition for cert. I read their reply. I've not heard any mention in any of the briefs irreparable harm. I haven't even heard them whisper that to anyone. They didn't even answer the question here today, what is their harm, other than having to sit through depositions. The case has been ordered for separate trials now, so the only discovery they're involved in is the case against themselves, Interstate, for coverage. I want to bring up also, as we all know, that the burden is on them to prove this irreparable harm.
Or is discovery going forward in anticipation of both trials, or was discovery stayed as to one trial?
The products liability case has been stayed, and the coverage issue is to be tried first. So there's absolutely no prejudice here. They haven't even alleged any prejudice other than when they alleged it to the trial court, and this was the transcript, this was a pretty knockdown, drag-out hearing, and a lot of information concerning severances and separate trials and the difference between Rule 1.270B and Rule 1.250A. And I asked Mr. Matthews and Mr. Bott at the trial level, I said, show the judge one case in the United States of America, not just in Florida, in the United States of America, where the court has dismissed this case for non-joinder. One case under Rule 1.250. There is none. The proper remedy, is what the trial court said, was to order separate trials under 1.270B.
Well, they're saying that's not enough. It has to be severed.
And where's their authority for that?
Counsel, does the misjoinder statute even apply in this case?
It doesn't for several reasons. Number one, and the main reason, is that they didn't comply with the statute concerning joinder. And that statute, the joinder statute says they cannot join the insurance company unless they deny coverage. Okay. But the denial of coverage has to be pursuant to 627.4262. And that says, it doesn't give them an option of and or. 627.4262 says that you have to file a reservation of rights and not or, and within 60 days of compliance with paragraph A, which is within 30 days after the liability insurer knew or should have known of the coverage defense, written notice of reservation of rights to assert a coverage defense is given. So basically, they failed to comply with this statute, the clear language of it, and by doing so, they can be joined. So really, the joinder statute doesn't even apply because they haven't denied coverage under the statute. And that statute specifically says that. So that's one of the issues. The other issue is we have an assignment from the Choctaw Club under our COBUS agreement. This really wasn't, I don't want to get into this or off track, but this was more than just a COBUS agreement and a consent judgment. We had a full hour and 45-minute evidentiary hearing before the court on this COBUS agreement.
On the reasonableness of the judgment.
Yes. And the judge upheld the reasonableness of the judgment by summary judgment because he remembered the hearing and remembered the evidence that was introduced and all the. So it wasn't just your standard where you walk in with a judgment and say, here, judge, sign this. It was a consent judgment. There was an hour and 45-minute hearing on this issue. So since we have that assignment from Choctaw, we've also filed a direct action against Interstate on behalf of Choctaw Touchdown Club for coverage. So I think their argument falls in several reasons because, and really, all this is going to be decided again on appeal. So, I mean, how can they get cert here? I was a little confused on that to begin with. I mean, I think we all know that if it's available after final judgment, we shouldn't be here for cert. And one other point concerning any mention they never mention the word irreparable harm. They mention prejudice.
All right, now, as I understand their position, it is that separate trials, that's not enough.
Right.
We have to have severance.
Right.
All right, so now how would you, so what happens on appeal? Let's say there are separate trials.
Right.
And they lose in both. And then what is the relief on appeal? If that's the only
they can appeal.
They can demonstrate.
They can appeal these issues on direct appeal. They can appeal the final judgment and raise these issues.
You're willing to accept the risk that on appeal, whether we will or will not say they should have been severed.
Sure. Well, the trial judge looked at this very closely, and we argued, and the distinction, is what he said. I think I quoted in my brief. It says, he asked them, what's their prejudice? What's their prejudice?
But I mean, your argument though is on irreparable harm that there's no irreparable harm here. If the trial court is wrong, this court can later say, well, you should have severed them.
Sure.
And we're going to make all the parties go through the expense and the time of new trials on both issues and severed proceedings.
What was their answer when Judge Remington asked them?
They said that they would have to sit through discovery on the products liability case, which has not happened. That case has been stayed, so there's absolutely,
pending the liability determination. The coverage. Everything's going to be stayed, and coverage is going to be determined first.
Right. Trial is set in February, but the judge has granted summary judgment on that issue, so we'll be back here, I'm sure, before you on that issue at some point.
Coverage has already been determined. Is that in this record?
It is.
I'm not asking you to go outside the record.
Yes, sir, and I apologize. I thought he mentioned that.
No, I asked it. It's
okay.
All right.
I think Mr. Bob.
The cases are clear that if the contention is that a motion to dismiss should have been granted, sparing the movant the expense of the trial, that is not an adequate basis on which to get a writ of certiorari.
According to Padovano, it's not, and according to the case, I've got the site on that
so
case.
So if discovery and the trial is not enough, then having to sit through a few depositions in the event the stay is dissolved would hardly be enough.
That's our position. I think that's the position of this court just recently in July of 2010, where it laid out all of the cases concerning cert. It's at Baldwin versus Shands Teaching Hospital. Just came out in July 2010. This court went through, gave a great listing of all the cases concerning irreparable harm and the burden of proof, and I looked through the whole brief. I never saw one whisper or one mention. I don't mean to use that word as facetious, but they never mentioned how are they harmed. So I think they failed to meet their burden here just based on that one issue. I wanted to touch, if I've got just a few minutes, on the certified mail issue. They were served with notice of the complaint by personal service. The judge gave them, like I say, we had a 2-hour hearing or an hour-and-a-half hearing on that issue of their motion to dismiss. I want to bring up one other point that I think is real important here. Funtastic filed the original motion to sever pursuant to 1.270B. Interstate filed its own motion to sever. They call it sever, but it's really separate trials, and that I've learned since I've studied this issue. they filed their own motion for separate trials under Rule 1.270B. So we said, we don't object. We sent an order to the judge saying, we all agree. The other defendants agree. Everyone agrees to separate trials. Well, then Interstate comes back 24 hours before our main hearing on Funtastic's motion, because they then withdrew their consent to the order, and files this new motion to dismiss and sever under 1.250. So I'm sitting here at the hearing basically cold. I've got this memo that I just got the night before the hearing, and I'm looking at it that day, and I argued this basically off the cuff by just looking at it and quickly. So they had plenty of notice and opportunity to object. They objected to the joiner. They raised all these same issues to the trial court that they can't be joined. We went through all of this. So they had sufficient. I think the purpose of that certified mail notice is due process. That's a notice and opportunity to be heard. And they kind of made, I don't want to use this term, but they didn't agree with my little cite in my brief concerning certified mail notice. And I think it's right on point that the purpose of that is to give due process notice and opportunity to be heard. And the trial court gave them more than ample opportunity to be heard. So I just wanted to raise that issue just for that purpose. Thank you very much.
Thank you very much.
May it please court again. I just wanted to follow up on a few things. There was some discussion about irreparable harm and such as that. I think, again, the point is, under the non-joinder statute, irreparable harm is really not an issue. It is strictly a matter of...
It is an issue for us if you want us to grant a petition for writ of certiorari.
Yes, sir. And so I guess the point is, in terms of what has to be proved in terms of irreparable harm, we do feel like by being bogged down in this other case...
I mean, if we were to rule in your favor, we would essentially be construing that statute to presume irreparable harm.
Yes, sir.
And
Yes.
That'd be a pretty broad construction of that statute. Do you agree?
Well, I guess...
Especially since separate trials have been ordered.
Well, yes, sir. The separate trials are under 1.270, which is again, that statute, if you keep that in mind, it's you have consolidation where there's common questions of law or fact. There are no common questions of law or fact in the insurance case versus the tort case. Those are completely separate, so there's no overlap there. And so the point being is that under the non-joinder statute, it makes it non-discretionary for the trial court. And by having us all bogged down in this case, when you really step back and look at the big picture, there's a reason why there are no other reported cases that are in the same procedural posture. They all are broken into two parts. And again, there's several cases that we've got for you that go right to this. This DeMio against Frenchie's case is a case that's exactly on point. It's a Fourth Circuit case. There, an insurance company denied coverage. It was a motorcycle helmet case. The plaintiff tried to bring the insurance company in with the tort defendant, and the court said no, the non-joinder statute.
Was that a case involving extraordinary relief? You say Fourth Circuit. That's the Fourth Federal Circuit. You meant Fourth District?
No, it's the Fourth District. Fourth District.
Did the Fourth District there hold that that was a direct appeal, was it not?
Yes, sir, it was. You also had the Merchants and Business Insurance versus Bennis case. That was a cert petition. State Farm against Nail was a cert petition. And then also there was a case called General Star against Boren. I don't believe that's in our brief. It's 895 Southern 2nd 1136, Second Circuit, 2005. Same thing there. There was a general contractor suing a sub, and then the general contractor also claimed it was an additional insurer, sort of like here, and the Second Circuit said that the two cases had to be severed. So again, there's plenty of law that says you have to sever these two cases out.
Now, in any of those cases, had separate trials occurred?
Under 1.270, no, sir. Not that I recall. They were all lumped together, and then either...
For trial.
Yes, sir, and the whole case was together, as far as I could tell.
It seems to me that the hurdle you face is, and certainly we're going to be considering this, is if we deny extraordinary relief, and these proceedings go via separate trials, and if you do not prevail and you appeal, obviously the appellee bears a great risk here by prevailing today. If they go through that procedure and then we were to, on direct appeal, say, no, under the non-joinder statute, this was incorrectly handled. But the problem I see is that if it comes up to us in that posture, we're then obligated by Florida law to apply the harmless error statute. And if we don't see any harmless error in that procedure, under the legislature's mandate, we can't reverse even there. In other words, if the separate trials don't involve harmful error.
Yes, and so, again, I guess I would come back to say, if you're only looking at 1.270 or 1.250, you might say there's some discretion for the trial court. But the way we look at the plain language of the non-joinder statute...
Your argument, it seems to me, may rise and fall on whether we interpret the non-joinder statute to presume irreparable harm.
Possibly so, but again, I would just say that the plain face of the language requires the separation. Okay. Thank you very much.
All right, thank you.